And Dr. Quadri is Associate Professor of History, Director of Undergraduate Studies in History, and Director of the Program in Religious Studies at the University of Illinois at Chicago. He is a graduate of McGill University and is the recipient of many fellowships like the American Council of Learned Societies, the Woodrow Wilson National Fellowship Foundation, the American Center for Oriental Research in Jordan, the American Research Center in Egypt, the Social Sciences and Humanities Research Council, and he has also taught at the Qatar Faculty of Islamic Studies in Doha. His publications, his research, it seems to me, has dealt with two major themes, as far as I can gather from the bio here, from the short bio. On the one hand, the relationship between Islamic categories or Islamic law and the colonial experience, with the publication, the recent publication in 2021 of a book entitled Transformations of Tradition, Islamic Law in Colonial Modernity, Oxford University Press. And the other major theme is the connection between law and ethics, with the book entitled Moral Habituation in the Law, Rethinking the Ethics of the Sharia. No, this is an article from 2019. Dr. Quadri will be speaking to us about Aspiration, Admiration, and Moral Exemplars, a virtue ethical reading of Islamic legal texts. Dr. Quadri, the floor is yours for 20 minutes, I'm afraid, only.
Okay, thank you very much. Can you hear me okay?
Yes.
Okay, wonderful. So thank you very much to Dr. Qassa for the introduction, and then to the organizers, Dr. Mu'taz, Mona Ali Madi, for really putting together what is a really impressive conference. I should say that I've already learned quite a lot from this conference, some of which I think will force me to reconsider some of what I say today, but that's wonderful, and I look forward to the next couple of panels as well, next 3 panels as well. So my comments here are somewhat of a preliminary exploration, so I do welcome comments and suggestions. As someone who has worked primarily on Islamic legal texts, fiqh, usul fiqh, related disciplines, my interest in the topic of this conference might merit some explanation by way of background. The study of virtue ethics has not historically occupied a place of much prominence within the study of Islamic law and the analysis of Islamic legal texts. This is in contrast to, say, Sufism or Falsafa, whose virtue ethical components are more readily identifiable and indeed have been so identified. One of the questions I'm interested in interrogating is whether that relative neglect as it pertains to Islamic law is justifiable. As you might guess from the title of this paper and my enthusiasm for this conference, I'm inclined to think that it is not, and that as a result, the absence of a virtue ethical reading of Islamic legal texts obscures aspects of the way Islamic law functions. This is not to say that we have anything approaching a full reading of virtue ethics in Islamic law, though I should point out that our colleague Freie Buhafa's work examining the connections between law and philosophy, law and ethics in Farabi and Ibn Rushd. But I think we're still in the stage of piecing together the nature of this relationship. Rather than a comprehensive theory, though, I think it's fruitful for my purposes to start with moments of overlap and points of convergence which deserve further exploration to flesh out their implications and underlying commitments. One such area I've had the opportunity to explore is the place of habituation and moral cultivation in works of substantive jurisprudence, furu. What I found in an article I published a couple of years ago, which was referenced, is that the centrality of habituation to virtue ethics that has long been recognized can be found not only in the Arabic akhlaq tradition, but also in a field like jurisprudence with which it shares a common culture of normativity. This parallel is obscured from view, I argue, if one sets out to look for identical discussions structured in similarly formulaic ways, or the transposition of akhlaqi terminology to fiqh. References to ada, habit, or ta'weed, habituation, are not so easily found in fiqh, but that is not to say that the same intellectual ground is not covered there. Indeed, the hadith that states that goodness is a habit and evil is obstinate persistence remains a relevant touch point, or in fact, overarching principle in the fiqh literature. There are, in fact, a range of terms whose function is to do much of the conceptual work found in akhlaq works linking habituation to habitus or disposition. In that article, I gave 3, idman, as in the example given in the Mudawwana of Sahnun of the one who plays chess continually, al-mudmin alayha, or the example of the habitual drinker, mudmin al-khamr, in the Asl of Shaybani. Iqama, as is said by Hanafis of the person who repeatedly transacts in usury, al-muqim alayhi, or israr, a widely used concept which suffused the fiqh tradition most prominently through a legal maxim stressing the link between repetition and moral standing. This paper grows out of that material, though it goes in a different direction. What I found is that the concept of Israr came to be such a central part of the structure of fiqh that it found its way into the fundamental Sharia categorization of human action. To understand the process by which this developed and its ethical implications, we must turn our attention away from the moral agent and towards the moral exemplar. The importance of the model to which a virtuous agent aspires, upon which he patterns his behavior, and against which he is measured, is an important element of Aristotle's understanding of the Nicomachean ethics. The sentiment is also found in the akhlaq tradition, as in the statement of Yahya bin Adi in his Tahzib al-Akhlaq, that the complete man, al-insan al-tam, shall devote himself to implementing what virtuous people have bidden to be implemented and what the sages who have gone before have advised to be made habitual. For Muslims, of course, well, I say of course, although I'm cognizant of what went before me, but I wrote here, for Muslims, of course, the ultimate moral exemplar is the Prophet Muhammad, and the example to be cultivated is his Sunnah. In a series of discussions preoccupied with formalizing the concept, the later Hanafi tradition concerned itself with how exactly Sunnah ought to be defined. The 18th century encyclopedia, Kashaf Istilahat al-Funun, lists a number of definitions from these later discussions, with the most common understanding in the entry, the Sunnah as a well-trodden path, a tariqa al-masluka fi din, being already anticipated by Kamal ad-Din ibn al-Humam, 15th century, and importantly in language that is familiar to my concern with habituation. He says, the Sunnah is a habitual or customary way, and in Hanafi fiqh, that which has been assiduously and consistently practiced by the Prophet. ما واظب على فعله. For Ibn al-Humam, the Prophet's occasional departures from this practice for no discernible reason is what distinguishes the Sunnah from the obligatory, wajib. This is a distinction made by Hanafis and not always found in other madhahib. On the other hand, the relative assiduity and consistency with which he practiced an action differentiates the Sunnah from the merely recommended, mandub or mustahab, an act that may not have been even practiced by the Prophet, even if it was something he considered desirable. In the ongoing quest for precision, Ibn Nujaym, 16th century, noted Ibn al-Humam's definition before modifying it. He agreed that the Sunnah is that which the Prophet did with assiduity and consistency, muwadhaba, but envisioned it as a super category that is exhausted by 2 subnorms, the Sunnah mu'akkada, emphasized Sunnah, which the Prophet never omitted, and the Sunnah ghayr mu'akkada, which he sometimes did leave out. In the 17th century, Al-Hasfafi displaced the stipulation of muwadhaba, identifying it as an exclusive characteristic of the Sunnah mu'akkada. The emphasized Sunnah was a category that had been used by earlier jurists, but in this later trajectory, it was theorized in a particular way, one that is important for our interests, the notion of a habitual behavior of the Prophet as moral exemplar. So I'm going to say a little bit more about this category before seeing how it kind of relates to other topics I'm interested in. The emergence of the category of the Sunnah Mu'akkada, however, allows us to glimpse two distinct but related attitudes towards the Prophet as moral exemplar: emulation and admiration. We can see this by examining responses by Hanafi jurists to the question of what to make of the person who disregards the Prophet's example. At least two general responses can be found in the literature. The first derives from Ibn Nujaym's discussion of a particular case, the person who omits the omits the sunnah of raising the hands to begin the prayer. Jurists disagreed over whether or not omitting a sunnah like this is sinful, with Ibn Nujaym preferring an intermediate position. He says it is sinful if one does so habitually, but not if he omits it only on occasion. Here, Ibn Nujaym invokes once more the familiar notion of habit, and notably does so in a manner that parallels his categorization of the two types of sunnah discussed previously. Indeed, he recapitulates his summary of the discussion by suggesting that those who regard the omission as sinful do so because they think the act is a sunnah mu'akkada, while those who do not regard it as sinful consider it instead to be supererogatory. On Ibn Nujaym's reading, then, the notion of regular habit emerges as a key component of the Sunnah Mu'akkada from two perspectives. An act is defined as such because the Prophet practiced it regularly without ever omitting it, thereby giving it a weightier normative status. And two, a Muslim's disregard for such a Sunnah Mu'akkada is regarded as sinful only when it is habitual. The second approach is of more direct interest to us, I think, in this paper. It derives from the texts of two 14th century Hanafis, Az-Zayla'i and At-Taftazani, who, in an attempt to distinguish between two different norms, the makruh tahrimi, the prohibitively disliked, and the straightforward haram, prohibited, referred to their positive counterparts to provide some context. These positive counterparts are the Sunnah Mu'akkada and the Wajib. Each of these writers settled on the principle that while the sanction for omitting an obligatory matter is punishment in hellfire, disregard for a Sunnah Mu'akkada merits only a censure that takes the form of the agent being deprived of the Prophet's intercession, Hirman al-Shafa'a, on the Day of Judgment. This latter position was based on the hadith, "He who leads my Sunnah will not enjoy my intercession." This formulation, I think, is deeply ethical. Its form of censure is the distancing from the moral exemplar and figure of adoration, rather than a physical punishment, even if otherworldly. The appearance of Shafa'a in this discussion allows us a window onto a less discussed aspect of Sunnah. It reveals that the Prophet is depicted in the fiqh literature as not just a model to emulate, a well-trodden path to follow, but also, crucially, a target of admiration. The philosopher Linda Zagzebski, who's been referred to before, has argued at length in favor of an exemplarist moral theory, a theory of virtue centered on orienting oneself toward moral exemplars as the pre-theoretic constants or elements of our moral lives. The central emotion she identifies with this way of thinking about morality is admiration. Indeed, she suggests that the admirability of the exemplar is prior to his imitability. She writes, "What I mean by an exemplar is a paradigmatically good person. An exemplar is a person who is most admirable. We identify the admirable by the emotion of admiration. A person who is admirable in some respect is imitable in that respect. This is rough because there are many reasons why we do not or cannot imitate the admirable, but the feeling of admiration is a kind of attraction that carries with it the impetus to imitate." It seems to me that the invocation of Shafa'a in connection with Sunnah gives us license to think that this moral psychology is also at play in the fiqh literature. But let me try to offer a little more by way of justification in what is still admittedly a preliminary avenue of investigation. The work that is most often cited by the fuqaha in connection with Shafa'a is the 13th century commentary by An-Nawawi on the Hadith collection of Muslim. Shafa'a, as this audience will certainly know, is an intercession by the Prophet, and in some limited cases, other righteous people, in the afterlife. Nawawi gives us a five-fold categorization of the sorts of intercessions available to the Prophet. 1, granting those standing on the day of judgment respite from their terror and hastening their moment of judgment. 2, ushering into paradise those who deserve it without any reckoning whatsoever. 3, interceding on behalf of those deserving of hell. And 4, rescuing those who have already entered hell and bringing them out of it. And 5, raising the status of those in paradise. The precise enumeration is one that is heavily, this precise enumeration is one that is heavily drawn from foundational nusus, from the Quran and Hadith, but there is another insightful categorization of shafa'ah that strikes a slightly different tone. It is found in a work attributed to Al-Ghazali, though his authorship is the subject of serious dispute, titled Al-Madnoon Bihi Ala Ghayr Ahlihi. In it, Ghazali, or pseudo-Ghazali, describes shafa'ah as, quote, a light that radiates from the divine presence to the prophetic essence, Jawhar al-Nubuwah, and from there spreads to every substance that is strengthened by its affinity or correspondence to the prophetic essence by virtue of deep or ardent adoration, shiddat al-muhabba, or assiduously attending to the sunnah, mu'adhaba, or by invoking prayers and peace on him, salat alayhi. I would submit that this formulation brings us back nicely to the 2 modes of orienting toward the sunnah we mentioned earlier. 1, assiduously emulating prophetic practice, and 2, admiration through deep love and reverential prayers. Now, I've translated mahabba as adoration precisely because it captures that dual sense of veneration and admiration I wish to suggest here as part of the moral psychology of a moral agent as envisioned in fiqh. Digging deeper into the word and the way it has been conceptualized gives us, I think, even stronger reasons for us to identify mahabba with admiration. The first thing to say is that kind of on a linguistic level, mahabba is the kind of inclination towards something. And so this maps on to the definition that Zagzebski gives on the idea of an attraction to a moral exemplar. Raghib al-Isfahani defines mahabba as an irada for that which you deem as good, or what you think is as good, implicating a moral component. Back to At-Tanwi in the Kashaf, Istalahat al-Funun, who has a lengthier discussion. He writes, as for our mahabba for other than God, it is an emotion or modality based on an assessment of kamal, perfection in him, that is the person other than God. Quoting Fakhruddin al-Razi, he explains further the presence of kamal by reference to prophets and saints. We adore prophets and saints purely as a result of the attribution to them of kamal. When we hear stories of the courageous, like Rustam and Asfandiyar, these are of course heroes of Ferdowsi Shahnameh, and come to know of the nature of their courage, our hearts incline towards them. Again, this kind of notion of inclination that Zagzebski points to. This excerpt also points to another aspect of her theory of moral exemplarism, which is the centrality of stories and narrative. The reference by Razi to Ferdowsi's epic suggests also that narratives of virtuous people are central to the normative Muslim understanding of admiration as an integral component of virtue. So to conclude, I've tried to argue in this paper that there are embedded in Islamic legal texts elements of virtue ethics, if not a full-out virtue ethical theory, which illuminate our understanding of Islamic law and of Islamic intellectual history more broadly. These are not visible if we construe virtue ethics as located solely within the terms of the akhlaq tradition or the falsafa tradition. Rather, Islamic legal texts make use of a particular vocabulary and genre-specific formulations, which, though they depart from the more famous articulations of virtue ethics in appearance, in fact share a common normative ground. The concept of Sunnah, and in particular its place in particular jurisprudential questions, offer a particular fertile ground for investigating this common normativity. One iteration of Sunnah focuses on the familiar definition of emulating the Prophet Muhammad, following a well-trodden path which instantiates virtues within oneself and keeps vices at bay. We might call this a Sunnah of aspiration. A related approach, however, foregrounds the notion of adoration and admiration as key elements of a moral psychology and a larger cultural intellectual milieu. It is by looking at the discussions of Shafa'a in their overlaps and intersections with Sunnah that this approach becomes more readily apparent. Nor is this simply an afterthought. That Muhabba is a fundamental part of the structure of Muslim normativity can be found in An-Nawawi's explanation, also in the Sharh on Sahih Muslim, that having Muhabba for the Prophet, indeed a Muhabba that exceeds one's love for one's own family, is an obligation. Viewed then from the perspective of the world of Islamic law, the moral exemplar occupies a noteworthy dual role, at once an object of aspiration and admiration. Thank you.
Thank you very much. Perfect timing. I'm sure we will go back to the many points you raised in the following discussion. And it